Welcome back. Have you had your rights violated by law enforcement or policy enforcers, but you don't know what to do? Here's a code that you can use in order to get your remedy that you deserve. Enough yap, let's dive in. So first, we gotta ask, where do people sue the police when their rights are violated? Here we go. People sue police officers for violating their rights in either federal or state courts. I say do it in both, depending on the nature of the claim. Federal lawsuits are often brought under 42 U.S.C. 1983, while state lawsuits are based on state laws. So you got to read the state constitution. Additionally, individuals can file complaints with internal affair units within police departments or the Department of Justice. So what I would do is first file a complaint, a criminal complaint, with the internal affairs unit of that police department. Then from there, you would do a case in the state court. Then you would go to federal court, because if you win in either of those, you can go after their bonds. Then you will go to the state's insurance commissioner, create a criminal complaint, and that will put a lien on their bonds. So let's quickly read 42 U.S.C. 1983. Here we have 42 U.S.C. 1983, civil action for deprivation of rights. Let's read. Here we go. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer for any act or omission taken in such officer's judicial capacity, policy enforcers, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. For the purposes of this section, any act of Congress applicable exclusively to the District of Columbia are considered to be a statute of the District of Columbia. So you can see here, they're saying that statutes, ordinances, regulations, customs, or usage, rules, codes are under color of law because they don't pertain to natural men and women. And you're going to have to agree or consent to that law or authority by either acquiescence, implied consent, or explicit consent. Also, it says right below that the judicial officer will not get injunctive relief if this actually proves to be true. So they can't have qualified immunity. All that qualified immunity goes out the window when you bring this action to them and you prove your case without a shadow of a doubt. So to wrap it up, 42 U.S.C. 1983 is just one of the remedies that you can use in order to get justice from policy enforcers violating your natural rights. Again, there must be a corpus delicti. I did a whole post on that. Corpus delicti is the body of the crime. It has to be a natural man and woman. It cannot be a fictitious entity or a governmental entity or a fictitious state. So keep that in mind. And I hope this helped out. And until next time, Sacre Corpus.